Yes. Which one?
115.
115.
115.
115. Okay.
Yes.
Then at 12:30 we can start. 12:30. Okay. Yes. Yes, sir.
I request your lordship, I have concluded the argument in respect of one criminal appeal.
Yeah.
And your lordship, after conclusion, told me that you will file a synopsis of the points which you raised.
Yes.
Today it is not possible on Thursday.
All right. All right. Okay. All right. Yes.
My consultations.
No. Reports.
Reports item number 1 I have given,
Yes.
and 2 is counsel for the appellant to obtain instruction.
Right. Item 1. Yes. Yes. Item 2. Item 2.
Then the counsel for the petitioner is to obtain instruction.
Sorry.
Counsel for the petitioner is to obtain instruction in item number 2, my lords. He was directed to take instruction. Item number 2.
No. The last date of hearing, counsel for the state seeks one more week time to get the instructions.
But in noting it was
You are supposed to get it. Anyway, we'll see. Next 3.
3,
Let me-
4 and 5 instruction has not been received.
3, 4, and 5.
5, yes.
Okay. One more week.
Yes, ma'am.
3, 4, and 4. Last order is not complied. One more week. Yes. Next. 6.
6, 7, 8, 9. The report has not been received.
What is happening? Why? See, you have taken thrice time. One more week, huh? One more week. Yes, next.
I don't 10.
10.
My lord, I'm seeking a clarification of your lordship's order
Yes.
on the ground
Then,
that
my lord, last occasion, my lordship died to file the response. This is the judgment which was passed, my lordship, and that is reporting. So the states are filed the response. A lot of I paid a lot of letter from
my
the
lordship may hear me for a moment. Thank you. My lord, I had come up before your lordship for quashing of the proceeding as a whole. On your lordship may kindly see page 9 of that interim application.
Yes.
Such and such counsel for the petitioner, in addition to the aforementioned 2 offences, the taking cognizance of the said offences by the land tried court is misplaced under law. The petitioners are neither the owner of the spa nor the manager, rather they are the customers. So your lordship was kind enough to quash a portion of the charge.
And the
That-
first judgment.
First judgment. That is in fact the reported judgment. In page 19, your lordship may kindly see paragraph.
That judgment you want to.
Yes. Why I'm bringing, your lordship may kindly have a glance to page 19 for a moment.
19, huh?
19.
19. Yes.
Therefore, I am of the considered view that this is a fit case where the court in exercising the inherent
19 of which IA?
Item number 1294 of 2026.
Yes. 19. Yes.
Therefore, I am of the considered view that this is a fit case where this court in exercising the inherent jurisdiction under 482 quashed the cognizance order insofar as offences under 370 subsection 3.
That's the reason I asked the state.
Yes.
So in fact, the first order, first judgment of mine is the correct judgment.
But
Subsequently, you are engaging some wrong judgment. They should have moved an application for correcting it. And instead of that, I indicated that. That's the reason and you have not followed it, appears.
That's why I'm praying for some more time. And 362 is there in the proceeding. Selfish. The judgment cannot be changed or altered. Apart from that, my lord, we can take some more time to file the response that respect.
It's a legal issue. What response? You argue it.
my lord may kindly see the subsequent judgment delivered by your lordship.
No, that's that. I have understood it. Entire thing I have quashed. And therefore you say that the earlier judgment which I passed, there partly why have you quashed? You quash the entire thing. That's what you are saying.
Because both the petitioners are on the same footing.
Same
They are
thing
the customers.
from the same incident.
Same
Incident.
status is same manner. Both are customers. That is the categorical finding by your lordship.
And my
In
lordship,
my
that
case,
is to
he
the-
was a customer. In this
Don't you think that you should go to some other court saying that this judge is passing different orders?
the-
Malan, I should refrain myself from saying anything in open court.
9 to 24, my lordship.
And you should have see. I
And
couldn't.
direct to trial will be.
But now see the problem is the first judgment which I passed, this is the correct judgment. So subsequently, somehow this is missed.
And this is the so far the criminal case there. That the different person is putting in a different way. Subject my lordship correction. Here in the case, my lordship friend is submitting that they both are the same footing. That part is he is the customer and the order passed in the so far as the Tapan Mishra case it is the customer. And that part I know. But here is that order was passed on 9 to 24.
He is only saying that immoral trafficking act
Yes, that-
person has to go.
That
My earlier judgment is being customer if they have gone to the massaging center, and you can't prosecute them for 370 capital A and all.
it was.
That
Human trafficking and all. Because they have no clue. They went as a customer. So therefore, that human trafficking angle has to go. So that is the reason I quashed that part. I say that immorality is still there.
They should
He has to prosecute.
That's the trial.
And but in the subsequent, the same another customer comes, I quash the entire thing, relying upon the same judgment. You should have pointed out. There is no assistance. So this is how it is happening.
No, Mr. Naik.
You should have assisted properly.
এটা হচ্ছে পুরা এরো
He might have said that I am covered by these judgments. I quashed it.
ତମେ ଥିଲ ମିଷ୍ଟର ନାୟକ ଆଉ କିଏ ଅଛି
This is how the assistance from the state council, then you have to suffer. He might have said that I am covered by these judgments. You said yes. Quash it. Finish. Thursday. You come Thursday. I will not. I'll have to change my judgment then. But anything which is tilted in favor of the accused has to be given to him, unless you say otherwise. We'll see.
But that is the reason I was not opening my mouth. Your lordship said that to go to other men. This answer I
You
was.
should have. Ideally, my judgment you can challenge who stops you, relying upon the subsequent one. You say that, see, this is the view of
Why should
same
I?
judge.
My lord, when my lord has passed two judgments, I should take the benefit of the second one. Why should I rely upon the first
The
one?
first one is the reported judgment.
Yes.
That's the right, correct judge.
Suppose the next judgment is my lordship which convict them. Can they say that we can get that benefit?
Conviction is not a benefit.
So,
Acquittal, obviously they will say, if it is acquitted,
As
acquittal
judgment
will say.
partly, my
Mr.
lordship
Naik,
partly allow.
such a seasoned counsel, I did not think that he will answer in this way.
Anyway, Thursday you,
My lord.
otherwise I'll have to do something. Yes,
Thursday in supplement list.
supplement. Yes.
Item number 11. Item number 11, there is one High Court of Orissa. Case number.
Application. Correct. Yes.
Item number 12.
I'm on behalf of AK Subudhi. Matlab extension, not only extension of time.
How many time you have taken extension?
IA number 1109/26.
Go to 3 weeks. Double. Provide order dated 24/4/2026. The petitioner was directed to surrender before the court below within a period of 3 weeks. For the reasons stated in the application, the counsel for the petitioner submits that the petitioner could not surrender within the time frame granted by this court. Hence, he seeks an extension. By way of last and final opportunity, petitioner is granted 2 weeks time. 2 weeks time from today to surrender and avail the benefit of the order dated 24/4/2026 passed by this court. This observation, the application is disposed of. Yes.
Item number 13.
Please, your lordship. Item 13. Last occasion, Miss Honorable Court directed to serve IA copies. I have already served.
Lordship, I am in this.
Yes. Copy of application. Which IA you are talking about?
IA for mediation, refer to mediation. The opposite party number 2, willing to
I know
Refer-
1028 by
1028 of 26.
Lordship, fact is that the petitioner released on bail on dated 20/5/26.
Yes.
Thereafter, the informant, in that period, the informant did not appear before this court and pray for the mediation. After getting the bail, now the IA has been filed regarding the 2 points. One point is she is willing to marry. Second point is he has provided a vehicle and did not give him the documents of the car. I am going to the second point, that the car is name of the petitioner, that is Anand Kumar Malik. I availed the loan. The car is I am the owner of the car. They are keeping my car forcibly. So there is no need to provide him documents. And
No, once I granted anticipatory bail,
right, sir.
why should I entertain this kind of application subsequently? Why should I entertain? You got the relief, you do whatever. You want to settle, go and settle.
Your lordship, the petitioner submit when the anticipatory bail grant, the petitioner submission, the petitioner willing to marry opposite party number 2. Point 6, your lordship order.
That even today, the petitioner is willing to marry the complainant,
Right.
but arrest would create hostility.
In this regard, sir, I am going to submit. The informant has given regarding that effect at Noyapalli police station, the FR was instituted against me.
No, don't argue on merit. You have made a statement that once I'm granted bail, then I will marry with the complainant. That is what she says.
No, sir. That is not my opinion.
That is the submission. This is order itself reflects.
No, sir. I told that I belong to SC caste. Why? She is a general caste. When FR was instituted, I was agreed to marry, but she refused.
No, just see. This is what you made the statement. That's what he says. Just see.
I submitted because Anand Kumar Malik is my dad. I submitted that time, but your order quoted that now my marriage was already fixed to another girl. My family has settled when she refused to marry.
Para 6, read the order of para 6.
Sir, I have already gone through the para 6.
Then, shall I recall the order?
Sir, even if I send this mediation, that I have no.
Then why are you opposing? Just see, read para 6.
Sir,
Please read para 6.
Sir, Learned Counsel for the petitioner submitted even today the petitioner who is willing to marry the complaint and arrest of create the hostility between the enhance of alliance may be married.
Because of that statement, this court is persuaded to grant you anticipatory bail. Today, after getting anticipatory bail, you wriggle out of it.
No, sir.
I'll recall this order.
In that time, sir, I was submitted, but if you want to send the mediation, then I have no objection.
Then
But-
why are you opposing? Go and try and find out why the order dated 20th of May 2026. The petitioner was granted the concession of anticipatory bail. It appears from para 6 of the said order that the counsel for the petitioner on instruction submitted before the court that the petitioner is willing to marry the complainant, once he is enlarged on bail. The complainant has moved the present application seeking a direction to refer the matter for mediation. On the ground that since after the petitioner obtained anticipatory bail from this court, the petitioner is trying to avoid the undertaking given to this court. Be that as it may, since the parties are agreeable for mediation, I feel it appropriate to refer the matter to the High Court Mediation Center. And when are you going to appear? Give the date. Appear on 20. The parties to appear before the coordinator of the mediation center, High Court Mediation Center on 20th. And the coordinators shall fix a date for exploring the possibility of settlement between the parties, and a place a report before this court by next date of hearing. Release the matter on 27th of August. Yes. I disposed of. Yes. Next.
Item number 14.
Yes.
It is covered by your lordship judgment. Company is not a party. Check bounce case.
Let us see. Let us see the complaint.
Complaint is at page 6.
Hemant Kumar Naik.
Sir.
Accused is Hemant Kumar Naik, isn't it?
Sir.
And who has issued the check? Let us see.
Check has been issued. What page? Page. The page didn't. Sir, page?
Ma Suntusi Infrastructure Private Limited.
Sir.
Yes.
See, between the same parties, your lordship has already interfered. I have filed the order.
Where is that?
Ochi, sir. Noting a Ochi.
Okay.
4974. Criminal case 4974. Kete flag dekhi?
Jai Ma Santoshi Infrastructure.
हाँ sir.
Yes. Who is appearing for the?
He was appearing.
What is there? Okay, I'll pass the order. I'll pass the order. Dispose of. Yes. Next.
Item number 15.
Give it,
Same thing, point,
No.
whether company is to be made a party on.
15, huh?
Yes,
Yes.
I'll just demonstrate from the complaint petition.
Yes.
Now, may kindly turn to page 8.
8. Okay. Yes. Who are you? What is your name? Name is Dilip Kumar.
Yes, the accused happens to be a recognized contractor in years 2017. Accused being a recognized contractor has taken various materials. Well, he did not name the company. He just said accused is a contractor. Now the cognizance was taken. Your lordship may kindly see at page 14.
Show me the check. Who has issued this?
Just so, madam. One thing. Page 14, your lordship may kindly see.
Yes.
Dilip Kumar Patel towards the mail. Prima facie materials to proceed against accused Dilip Kumar Patel, exit about such and such. Contractor, managing director, Isar Engineering Private Limited. Then the check was issued. Your lordship may kindly see page 19.
Yes.
For Isar Engineering Private Limited,
19.
authorized signature.
19. Yes.
Isar Engineering Private Limited, authorized signature.
Show me the notice 138B.
Yes.
Show me the notice.
My lord, I'll just take to the incorporation of companies that also.
That I know. It's
Yes.
all right.
Yes. Notice, my lord.
Show me the notice.
No, examination. Notice, my lord, I have not annexed. They have to demonstrate whether they have given notice to the company.
Show me if the notice was issued to the
Yes.
company,
Yes, then
then it is a curable defect.
Yes.
It is a curable defect. They can
Let them, because they are
move an application under 319 and get you
Yes.
in
My
the
lord,
company.
show
Where is show me? Do you have the copy or not? Do you have the copy of the notice issued? Whether you have issued notice to
Yes.
so see, the notice was issued to Dilip Kumar Patel, Managing Director, Isar Engineering Firm. It's again a debatable question, I tell you.
There one CC case also, they have stated Dilip Kumar Patel, contractor, managing director, Isar Engineering.
See, this is a curable defect. See, if the notice was issued to the managing director in official capacity,
In name, they should have issued to the managing director, Isar Engineering.
the idea of 138B is to put you in notice so that you can give back the check
Yes.
amount and all.
Yes,
The company is a juristic person.
correct.
You need not put the notice to the juristic person. And if it is given to the managing director,
But a company has to be represented through a managing director, and whether that is there or not.
next Tuesday,
That is there.
I have reserved a judgment in this line.
Yes.
Let me pass that judgment. We'll see.
And
Whoever gets the benefit.
Anita Hada case.
Anita Hada says, but subsequent judgment also says that a curable defect, if the notice on 138B is given to the managing director, even if notice is not given to the company, and it can be
Correct.
cured by
Absolutely correct.
bringing you under 319.
Yes, absolutely correct. But that should be addressed to the Isar Engineering managing director, represented by or represented by Dilip Kumar Patel, not Dilip Kumar Patel, managing director, Isar Engineering. Yeah, there is a distinction. Your Lordship may see that portion also. If they would have given to the managing director, Isar Engineering, represent through Dilip Kumar Patel, then I have no.
Or Dilip Kumar Patel, managing director, representing the company.
Then my lord matters. But here it is in person. It is a notice in person, not to the company. And company having not been made a party, that is also the view of judgment of this honorable court delivered by Honorable Justice in Lalit Beriwala case.
Let Mr. Dholo come.
Yes.
It's a technical issue. Let Mr.
This is only my point.
This is the only point. I know. I'll pass it over. Let him come. Let him come. Call him. You are in trouble. Call him. Yes.
It will be next Tuesday, today.
Oh, you are busy. Okay, Tuesday.
Interim order to continue.
Interim order. And you just check it up, huh? Yes. What he says. It is the you have given Dilip Kumar, managing director, HR. You don't say that Dilip Kumar, managing director, or through the company, or the company through managing director. Neither of these two is what they are missing. So therefore, how will you construe this notice? Whether it is compliance of 138B or not? That is the only issue.
Take one example, subject to, I'm not wasting your lordship. An injunction order is passed. Injunction against a company, injunction against a person. If I am made a party, injunction is squarely applicable to me. But if company is there and I am not there, nobody represents, then I am not liable to be injuncted.
Yes.
This is just like, well, it's a purely technical one.
Okay. Let the senior counsel come. Huh? Okay. Tuesday. Okay.
Next. Interim order in both.
Interim order in both. 15, 16. On the request of counsel for the respondent. Adjourn. Interim conflict. Yes. Next.
And on 17.
Yes.
I plead your lordship. Here we have the order challenge annexure 3, order dated 21st February 2024.
Yes.
Rejecting my petition to adduce evidence on behalf of the accused. On that day, my lord, he was on duty. Your lordship may kindly see the annexure 1, the letter dated 17 February 2024.
Let us see the impugn order. Complainant.
Yes.
Filed Hajira, advocate
Page
filed
12.
petition for time.
Page 12.
Page 12.
My lord.
Okay.
Advocate for the complainant filed Hajira, advocate for the accused filed a time petition. Time is rejected and defense evidence is closed. The date is posted for defense evidence and put up on so and so for argument.
Yes.
Your lordship may kindly see annexure 1.
1.
The letter of the block education officer Nimapata directing the petition to attend a 2 days current based teachers training that is scheduled to be held on 21st February 2024 and 22nd February 2024.
Yes.
That's the name of the petitioner as at serial number 3, page number 9.
You sought for adjournment.
Yes.
Isn't it?
Yes.
Let us see the application. What have you written? Have you written that?
Madam?
Have you said that?
Yes, yes,
You
yes.
inform the court that.
Yes. The accused person is a government teacher at Kanpur and due to his engagement in training
Government
at
teacher
Nimapada,
Kanpur.
for which he is unable to adduce evidence today. Hence,
Who is appearing?
Madam, Upon Lenka was
This
appearing.
complaint is under
NIA.
NI Act. Yes. Who is appearing?
One Sapan Kumar Lenka, the last appearance was appearing.
Is there a stay operating here?
Yes, yes.
Counter affidavit also filed by him.
What counters? Let us see. Not wait for this. Just see the annexure 2 to the counter. How many time you have sought time?
That's true. I have taken time. I don't
Then-
dispute that.
then-
But on the particular date, when
That
Lawrence-
particular date
when-
may
when
be-
the Lawrence trial court
You are the accused.
considering my difficulty has granted time. That is not difficult. Because that, I'm not.
How many
disputing
time
that.
you have taken adjournment? Just see. See the proceeding.
That order sheet I have not enclosed.
Where is the check amount? What is the check amount?
My check amount is 1 lakh somewhat. Total 2,50,000.
20% deposit I'll give.
Madam?
20%.
You will also fix any particular date so that
No,
I can.
that's what I'm going to do. 143. Comply 143. In any case, you have to comply 143. To deposit, I'll give you a opportunity. Otherwise, I'll dismiss it. 138 matters, see, when it 2022 it was filed.
Yes.
And you are taking time, just see how many time you have sought adjournment.
But on the date of
Whatever, see, I will give you intelligence. You deposit 20%. Subject to deposit 20%. In any case, 143 has to be complied.
Disputed amount, my lord. That.
143 has to be complied.
My lord.
You are lucky that he has not moved an application.
That.
Think that is an application. I will allow you to lead your defense evidence.
I will
pass the order.
judge my lord. That
All
will
right,
be
but-
for my case if in the trial court.
I could have allowed you to lead the defense evidence subject to cost. Okay, in almost all the matters I am putting cost. Okay, instead of cost, you deposit. That will be factor into the
That
final
will affect
adjudication.
my case.
Why should you waste my?
That will,
Are you interested to pay cost?
Some
Okay, are you interested to pay cost?
some
I'll impose a cost of 10,000 rupees.
But
That 10,000 rupees
10,000
go waste, unnecessary go waste.
but
Rather, you deposit in under
will
140.
also kindly visualize my difficulty.
Cost has to be imposed. See the
But I
Number
don't
of
dispute that
adjournments.
I have, but Lawrence trial court has considered.
why will you waste paying cost? You pay towards the check amount. It will be factored, and ultimately it will be factored into.
Yes.
You
You
will
also
be-
just said 10,000 I will deposit so that the subject without prejudice to the party.
that is 10%. 1 lakh rupees, 10%.
10,000 I will.
I don't know whether he has moved application under 143. Suppose I take 10%.
No, not more.
Suppose I 10%, he might have moved an application. He
No,
can
he has not.
20%.
He has not more. Not more.
Where is the check amount? Show me.
Check amount I have mentioned.
Where have you said?
Check I have not enclosed.
What is the amount? Let us understand.
2,50,000.
2 lakhs.
2 checks.
2 checks. But you have one matter only.
But one like same case. Dita ko gotta year is.
Then 20,000 to 10,000, 20,000.
10,000 টা করা তো সেটা without prejudice to the party.
Okay. Petitioner is agreed by the petitioner is an accused in the 1cc case number 2614 of 2022. Is agreed by the order dated 21/2/2024 passed by 11 JMFC closing the defense evidence by rejecting his application seeking for adjournment. Then counsel for the petitioner submits that he may be afforded one singular opportunity for leading defense evidence. None appears for the respondent. However, a counter affidavit has been filed by the opposite party, the complainant. In the counter affidavit, the proceeding of the court of JMFC in 1cc case number 2614 of 2022 is entry. From the proceedings, it is apparent that the present petitioner, being the accused, has been taking adjournment time to time. That perhaps the reason the trial court was not persuaded to allow further time and close the defense evidence by its order dated 21/2/2020. The petitioner is agreed by the same and has approached this court. A specific query was put to the legal counsel for the petitioner as to whether the complainant had moved any application under section 143A of NIA Tornado. The legal counsel for the petitioner submits that no such application has been moved by the petitioner, moved by the complainant. Taking into consideration the aforementioned, particularly the fact that the petitioner has been taking adjournment time to time, and the complaint case is pending since 2022. Although I'm not inclined to give indulgence, but fact remains that the petitioner, being an accused facing the criminal trial, is entitled to lead defense evidence, entitled to defense evidence. Therefore, a singular opportunity may be afforded to the petitioner for leading the defense evidence. In view of the same, the JMFC Bhubaneswar is directed to fix a particular date, and afford an opportunity to the petitioner to lead the defense evidence. It is made clear that a singular opportunity will be reserved to the petitioner to lead the defense evidence. On the same date, the petitioner shall conclude the defense evidence. The aforementioned opportunity is afforded to the petitioner to lead the defense evidence, subject to the petitioner depositing 10% of the taken up before the trial. With this observation, the petitioner stands allowed. Yes, next.
I don't know. And for the opposite part.
Yes. Let us see Passover, huh? Passover. What is it? Mediation failed. Mediation failed.
Mediation, it was not.
According to the metro, oh no, it was sent to mediation. Maybe to mediation. What happened to mediation?
No.
You have not participated at all. Once you appear, thereafter you disappear. And even you don't know whether the matter was referred to mediation.
No,
That is the, then
I'm associate was there, I am unaware.
it was,
Seeing your
it
lordship.
was referred to mediation, just see the order.
Yes, my lord, and I was not there. It could be informed me also.
Let the other side come. This is 138 matter again.
Yes,
You are for accused.
I'm for the complaint. I'm for the opposite part.
1,50,000 rupees.
Yes.
We'll finish it up right now. Let him come.
Certain documents were marked as exhibits. Against that order, he has come up.
Whatever this complaint case is pending since
21.
21, just see 138 matter, 21, 1,50,000 rupees check. I'll not give much indulgence. Let him come. We'll see. Finish it. Also, yes.
After lunch.
Yes. Also, yes. Next.
Item number 19.
Yes. Petitioner, by invoking the inherent jurisdiction of this court under 482 CRPC, is seeking quashing of the entire criminal proceeding initiated against him in I-1 CC case number 12 of 2024, now pending before the court of SDGM, Pampos, Udit Nagar, Raulkela, district Sundargarh. The matter has been pending since 13/5/2024. On 17/5/2024, when the matter was taken up, the counsel for the petitioner submitted when the parties, the counsel appearing for the parties submitted that the dispute had already been settled. However, the modalities was yet to be worked out. Therefore, they sought indulgence of this court. Accordingly, the matter was referred to the mediation center. The matter was taken up on 28/8/2024. None appeared for the parties. Subsequently, on 18/5/2024, also none appeared for the parties. And in the meantime, the mediator filed a report dated 6/9/2024. Inter alia, in 24, apprising this court that due to non-cooperation of the parties, the mediation remained unsuccessful. When the matter is taken up today, again none appeared for the petitioner. In view of the same, it appears that the petitioner is not interested to prosecute the present case. Accordingly, the same stands dismissed. Yes, next.
Item 20. May I please?
Yes.
Allowed. The accused is the petitioner before the lordships. Raising out of section 138 NIS. Two petitions were there. One is for to drop the case on the ground that the endorsement contact drawer, drawing blank and represent does not in itself constitute dishonor of check, an offence under section 139. And the other application was with the threat that the learned magistrate, that is SDJ Jaipur, is not competent to try the case. Both the applications were rejected, confirmed by the learned session judge. Now I am before your lordships. The lordship will kindly come to, there are two check return. One is dated 25th of May 2022.
23,
25th of May
22, yes.
2022.
yes.
At
Second,
page 21.
second one is
Second one is the very next day, 26th of May 2022.
yes.
A moment. That is annexure 2 and 3.
Yes.
The case of the complainant is that he has his, your lordship knows, pursuant to this 2015 amendment, series of judgments, including the latest is Joy Balaji Industries, reported in 2026 1/262.
Yes.
In that particular judgment, dealing with that, referring to that particular section, the Honorable Supreme Court has held the competent, the jurisdictional magistrate will be the payee's home branch, where his bank is situated. Now, in this case, if lordship may for a moment may kindly come to page 20, then I'll take your lordship to page 21.
20.
Page 20, your lordship says,
Service, by the way, service is complete. Service.
my lord, notices were issued. One learned, Mr. Vattabuddhi was appearing for the complainant, but I am very sorry, my lord, this matter came up before your lordships before vacation. I had some personal difficulty. I was out of station, so it was posted to today. But on the last date, I was told that he didn't appear.
The last date his appearance is there. Has he filed
His
vocal?
appearance has been noted, it has been reflected, but my associate told me that nobody represented the complainant.
Anyway, he has filed vocal now. I will not wait. Yes,
Yes.
next. Let us proceed. Yes.
Ma'am, page 20, annexure 2.
Yes.
The lordship may kindly see at the top right, date is 25th May 2022.
Yes.
And just below, my lord, your lordship may kindly see the endorsement. Axis Bank Limited and Service Branch, just below, my lord.
Yes.
Contact drawer, drawee bank and represent.
Yes.
So the complainant presented the check with the HDFC Bank, Jaipur. He was supplied with this check return memo. Thereafter, the very next day, he presented the check with the Axis Bank, Similiguda. The very next page,
Yes.
annexure 3, page 21.
Yes. That is another. That is another check. The same check.
Same check, same check.
Yes.
He presented with, your lordship knows once, because if unless I have a bank, I have an account with the concerned bank, I am not in a position to enclose the account pay check and present it for encashment or clearing.
Yes, I understood. Next.
So in this case, what has happened? If your lordship looks at page 21, the noting is funds insufficient. So he presented the case before the SDJM, learned SDJM, Jaipur. So cognizance has been taken. So my case is accepting that the law laid down by the Honorable Supreme Court in view of the amendment.
Yes.
This endorsement, contact drawer, drawee bank and represent or present again will not constitute an offence of dishonor of check. That is first. Second is,
there is a insufficient fund subsequent 26.
so then
Show me the notice. Show me the notice.
Notice, my lord. Sorry, my lords. Notice I have not annexed.
Show me that is the prime document.
Notice I have not annexed. I have annexed the copy of the complaint. If your lordship grants me some time.
Show me the notice if you have. We'll decide it right
Sorry,
now.
my lords. I have
You must be having the copy. That is the basic document.
No, my lord. I don't have.
All other thing which you have argued is a tribal thing that will be tried.
No, no. My another point is the learned magistrate that is JMFC learned JMFC Jaipur is not competent to try. It is only the learned SDJM Semeligoda. Is not competent. To try.
Let us see what are the reasoning given by.
My-
Yes.
I'll take your lordship to page 33.
33.
33.
Yes.
Finding my lords.
Yes.
This is the finding that we learned JMFC Jaipur.
Hmm.
Heard both parties. Just second.
Read the relevant part. Don't read.
My lord, these two paragraphs. Heard both the parties and perused the documents available on record. On perusal, it is found that the return memo was issued by the SDFC branch with an endorsement to contact the drawing bank and represent. Following the same instruction, the complainant approached the drawing bank, that is Axis Bank Semeligoda branch, and represented the memo of the drawer bank and accordingly collected the reasons from the drawing bank for not honoring the check in question, which stated funds insufficient in point number 29. Now coming to the question of cause of action, it is pretty clear that the cause of action arose within the jurisdiction of this court as the check was dishonored at SDFC Bank, Jaipur branch, and the complainant was...
Now, have you
directed-
show me the complaint now?
Complaint, my lords?
Huh.
Yes. Page, it begins from page annexure 1.
Yes.
It begins from page 15, ma'am.
Yes. What kind of complaints? There is nothing is written regarding the legal notice.
Pardon.
In the complaint, nothing is written regarding legal notice, whether it was served or whatever. Have you received the legal notice?
My lord,
That's the basic. If you have received a legal notice under 138B and all these things you have not said, the presumption against you under 139 operates. This is the rebuttable presumption. You have to face the trial and rebut it. As simple as that. Why are you taking me here and there?
my lord, I am given the competency to try that those are subject matters of trial with great respect.
Tell me whether you received the notice under 138B and if you have received and
Yes.
kept silent without replying, and if you have replied all these things, have you said that there?
No, reply notice of the accused has been referred, but I don't have.
Where is
copy.
that?
Page
Show
17.
me that.
Page 17. Page 17.
That's there. I could see what are the
But I don't
documents.
have the copy. If your lordship permits me, grants me some time.
Day after tomorrow. You come. Day after tomorrow. There is nothing. You have to face the trial.
No, no,
If you have not replied,
I'll participate in the trial. But so far as taking cognizance of the JMFC or the
see the complaint. Let's see the complaint para, second para.
No, I am not of the part of this whether this constitutes an offense of dishonor of check. 130. I am on the point of competency to try.
Just see
So-
para complaint. If you see complaint para 2, it refers to SDFC Bank Jaipur branch.
So SDFC branch, Jaipur branch, if your lordship sees the endorsement is contact drawer and drawer.
I will not go into all these things. It is the trial court who has to decide.
So
If you no
lordship
competence, you will get the benefit.
all I propose, my lord.
Why should I cut short the trial at this
I
stage?
participate in the trial.
Yes.
What I propose if a lordship permits. Your
And keep
lordship-
everything open, you won't argue.
Yes, sir. That is my humble sir.
Because
But-
you don't have a reply, you don't have a.
That those issues may be kept open.
You pass the order. Give it, huh? I'll pass the order.
And if your lordship permits, your lordship may kindly refer to this particular decision. Only this decision, because it is the latest decision. All the previous earlier decisions of the Honorable Supreme Court has been taken note.
This is Manmohan's judgment.
Yes, Justice J.P. Parker.
Oh, you just read Justice Manmohan's judgment. Just
Bridgestone, Yogesh.
everything is taken care of. That judgment, read it.
I'll go through.
Shall I put it day after tomorrow? You read that.
No, ma'ams. Your lordship.
You can
No,
read.
ma'ams. I'll go through your lordship and dispose because I have some possibility.
No, day after tomorrow. I'm talking about day after tomorrow.
No problem.
You read that judgment, so it will be enlightening.
Yes.
Read that judgment, so that would be better. Huh? I'll put it day after tomorrow.
Okay.
Just read it. You may
Okay.
throw some light on that. Okay.
Okay.
Day after tomorrow. Otherwise, I'll pass the same order.
Yes.
You tell me. Yes.
21.
Yes, my lord, I am for the opposite complainant in the court below, my lord. And the complainant died. And during pendence of the revision petition, the complainant died, my lord. I have filed a petition for substitution.
You have a respond.
In this, I am complaining in the court below and opposite in this revision.
What check amount?
They got 1,16,000.
You want to prosecute or what?
Eh?
You want to prosecute? You want to prosecute the case?
I want to prosecute the
Okay,
case.
learn counsel for the respondent.
The last occasion when I senior
Season,
Yes.
died in year 21. No limitation, no limitation. Because in file, nothing has been.
lordship can I am saying decision.
Yes, to file. Yes,
Allow
to
that
file.
good. Allow that good decision. Lordship can for a moment.
Yes.
The paragraph 16, your lordship can for a moment.
When was the complaint filed 2017 complaint?
The complaint filed in 2015, 2005, my lord.
No, here is that,
My
in this,
senior since I have filed a limitation for yes.
No, you are agreed by what? You are agreed by what? You are challenging the conviction.
And order of the conviction. And the accused.
Accused, you have been convicted. Their conviction is upheld by the appellate court. Therefore, revision. Then what do you want?
Potential revision, sir, he filed a petition for substitution of the.
You have been convicted by two court. Why don't you pay the money and finish it up?
Last occasion, my senior objected the since I have
Because,
filed a limitation petition.
Yes.
They are objected.
Here is filed a petition to substitute the opposite party, the complainant, without any explaining the delay and also limitation.
He will explain the delay. I'll condemn this.
No,
You have been convicted by two court. Why don't you pay the money? You can't keep on fighting on technicality. You have been convicted.
Actually, there is no
The
requirement.
130 matter.
On merit also.
I'll dismiss the thing, then you will be in trouble. Sentence is there. Then, so avoid sentence, you make payment, I will fix it. Installment or something.
I contacted the High Court last. The Lord knows me. He said that wherever.
So therefore you are so confident.
But
Even sentence will not be executed.
Last 2 times he objected for limitation.
What he's trying is, see, he has a right to object, that's not a.
I filed a substitution petition.
Even, what he says is, even if we dismiss the revision,
Yes, sir.
even if I dismiss the revision by allowing your application, whereabout is not known, what will you do with it?
Then you Lordship, I pray, direct for remediation the matter.
Right, he is,
Medicine जाओ notice आप जाओ इसे दिया
since the Lok Adalat, nobody appeared, the unnecessary the exercises, you know. In Lok Adalat also nobody appeared. Anyway,
Some other.
you seek in fact, I'll allow this application. Where, which paragraph you are relying on?
Paragraph 16.
16.
My last 3 lines. Since no limitation prescribed is for a person to apply the code for permission to prosecute the complaint case in place of complainant,
Yes.
there is no formal application under section 5 limitation
Yes,
is
yes.
required to condemn the delay. This is also 139 enactment.
Right. The petitioner is convicted by the judgment in order to so passed by so on appeal, the appellate court, namely recent decision so is upheld the agreed by the same present petition is pending and filed by the accused petitioner. During the pendency of this present revision petition, it appears the complainant, the respondent, has died. Therefore, an application, therefore, the present therefore, an application is filed for substitution. For the reasons stated in the application is allowed. Amendment of parties directly. File amendment of parties. Okay, you file. And
The duty of the
counsel appearing, you have to file, of course. Counsel appearing for the parties conjointly submits that one attempt may be made for the purpose of variation for the purpose of out of court settlement. Hence, they jointly request for sending the matter to mediation. High Court Mediation Center? Which district? Which district? Raulkela. District Court Raulkela. Mediation Center referred to. And awaiting the mediation report, release the matter on 6th August. 6th August.
6th August.
Yes.
That's why issue notice. After mediation, notice will be issued to the
Mediators shall issue notice to the parties and fix the date for exploring the possibility of settlement and file a report before this court by next date of hearing. Yes. Yes, next.
22. But the last order seems mediation has taken place.
A report has come.
Yes. I don't know what is the report, but
Is there this let them somebody where is yes? Who is there? Take out the report and keep. Nobody has cooperated, so nothing could happen.
nobody achieved. I received the last order. That was also my predicament.
Yes.
No contact with the.
I have also written my letter mail.
Both sides.
My register press to letter. Same thing.
What to do then?
Dispose the matter otherwise.
These are the this is a revision arising out of a conviction.
Conviction and 1 year sentence.
This
Always
80,000.
Can I try one thing? Let's see, the sentence, let's say directly.
I will direct what will happen. The client is not, his client is not there. Mr. Chinchani has already made that statement
Out
earlier.
of that order, it is for him to. It's a very fair suggestion made by the others.
No, otherwise I don't have contact. I have written the registered letter, it didn't turn up. That is
And what I'll do is,
2009.
I will uphold the conviction,
after the conviction.
grant probation, and increase the compensation. What is the compensation amount?
80,000. 1 lakh.
1 lakh. I'll increase it to 2 lakh.
Check amount is 80,000. Compensation is 1 lakh. Sentence is simple imprisonment of 1 year.
SI 1 year. Huh? PO. And the compensation is 1 lakh. Huh?
1 lakh.
Okay.
I'll increase
I'll increase the compensation to 2 lakh, and insofar as sentence is concerned, I'll grant probation. At least whenever he's cut, at least he will pay 2 lakh rupees.
Let the compensation remain as it is. The lordship may compensate or
Then I'll not give provision then. You can't have both. Can't have both. Either you go to jail or pay the money.
2 lakhs pay koi nahi,
1 lakh will increase, but in any case, he's not traceable to what lakh.
not traceable. I will be happy if he gets that.
Get some money. Let us see. Yes. Look at that.
It's a pro bono brief.
Okay.
23.
Champions for the petitioner.
Under 9 instruction, my lord, the petitioner died last 4 years. Exact date I don't know. I could not.
Yes, Mr. Pandai.
Well, we tried to communicate, but till date no results.
That is my instructions.
What you may dispose of in view of my learned seniors, if that
Can I
is.
record your statement?
So
I will abate it.
instruction received from the transport lawyer, your lordship, because my lord, the transport lawyer died the last 10 years.
After giving you information. I'll abate it about what. See, if he survives or anybody comes, then move application 394.
That liberty,
394, liberty. 394 application, there is no limitation. You can move application, no problem. Petitioner is accused in one case number 4. He has been convicted by the court.
here the petitioner was not the accused. Here the question was under the limitation.
1 CC cash disclosed.
1 CC
Oh,
was
dismissed. Let us see. Now let us see what is the impugn order. Impugn order 28/8/2009. Huh?
the-
Where is that impugn order?
Where the order. 28/8/2009.
Yes.
Not passed by the additional sessions of forward.
Yes. What does he say?
Criminal division number 25 of 2009.
The complaint petition which was presented on 25/2008 is in time as the complaint petition has shown sufficient cause for presentation of the same.
Therefore, condonation of delay petition was set aside. It is.
They will be directed to retrieve the complaint petition presented by the petitioner. After the magistrate had dismissed the complaint petition on the ground of limitation, which was reversed by the revisional court.
Set aside the order passed by the magistrate and mallard and restore the 1 CC.
1 CC case. Okay. Where is the order of the STJM?
That is mallard.
No, that is not annexed.
Annexed question.
No.
Nine.
Page 6.
6.
18/4/2009.
6. Okay. Yes. 6. Okay. Complaint Jitendra Kumar and name of the accused Suryakant. Then accused has come now, challenging that order. Right now. Petitioner is accused in 1 CC case number 12 of 2008. 12 of 2008. The respondent instituted the criminal complaint, initiated the criminal complaint against the petitioner under section 138 NI Act. What is the check amount?
Check amount mallard 2 lakhs. No, mallard 3 lakhs.
On the allegation of dishonor of the check of 10 lakh issued by the petitioner. White order dated, next one, white order dated 18/4/2009. The learned STJM, who is this STJM, na?
Mallard, everything.
Learned STJM SCM rejected dismissed the complaint case on the ground of dismissed the complaint case on the ground of on the ground that the same is barred by limitation. The said order was taken up in revision before the Court of Additional Sessions Judge Burger by filing Criminal Revision 25 of 2009 by the respondent complaint. By the impugn order, impugn judgment dated 28/8/2009, the Additional Sessions Judge Burger, while allowing the Criminal Revision 25 of 2009, revived the complaint case, and relegated the parties to participate in the trial. So agreed by the same, the present petitioner, being the accused, has filed the present petition, receiving the judgment of learned Additional Sessions Judge dated 28/8/2009, passed in Criminal Revision 25 of 2009.
Criminal Division 25.
During the it is submitted by the legal counsel for the parties that during the pendency of the present criminal division petition, the petitioner oblique accused has expired. Taking the next part, in view of the aforementioned, the present criminal petition is awaited in the absence of any application under section 394 CRPC by the LR or the next print. Okay. Yes.
24.
Yes.
Yes, someone already died. I'm for the opinion number 2, as a respondent Miller. We had no communication with the opposite party.
Then what to do?
Any other day or
Nobody is there to contest what you do.
already restricted lower court.
No, I will not keep it. These are the 138 matters pending from years together.
21/5 also directed the petitioner to implement.
Petitioner
Petition submits that the complaint Gopal has already expired. You give the LR. Then how will you move? Order 22 rule 9.
What should keep it to 13th last chance.
See, it is reported that the complainant, opposite party, Gopal Krishna Sahu, has already expired. However, the LRs of the said deceased respondent, particulars of the LRs of said deceased respondent has not been supplied by the land counsel for the opposite party to the to Mr. Tripathi, who is appearing for the petitioner. Hence, the revision petition cannot be proceeded. Land counsel for the petitioner respondent, by way of last and final opportunity, seeks 1 week time to supply the particulars of the LRs of the complainant oblique respondent. Release the matter on 13th of on 14th of this month, 14th July. It's made clear that if the respondent failed to supply the details of the LRs of the complainant respondent, the matter shall be proceeded without waiting for the same. The complaint petition is gone then. What will you do? Yes. Next. Wait for some time. Wait. Chalo. Kitna rela? 25.
They were also directing
Yes.
that the amount is of 2 lakhs prepared. In three cases, petition and we are same rate.
2 lakhs.
Yes, sir. Out of 11 lakhs, 50,000, but 2 lakhs is required.
Who is Umang Agarwal?
The successor of the opposite but died, brother. Now he is the son of the opposite.
Son of.
Yes.
Where is Mr. Naik?
Please, Lords, I'm
And,
appearing for the complimentary Lords. Lords may submit to those. Lords, you can see the last order. And in fact, the first order, 6th December 2016, Lords. Right, that order, Lordship had directed the respondent, the revisionist here to pay 1 lakh in each of the cases. There are 3 cases. So ideally, he should have paid 3 lakhs in order to show his bona fideness. Thereafter, Lordship directed that matter could be settled. Lordship, only they're paying 2 lakhs, Lordship. It is not
First point of time, he has guaranteed 2 lakhs.
It is not in honor. It is not honoring your Lordship's order.
In the period of 1 week, he has settled the amount, he has given the draft.
Now, how many cases are there?
3 cases. Lordship may submit to Lordship.
Each case 1 lakh rupees.
Yes, sir.
Each case 1 case.
But that's when I know that. 3 cases, 3 lakhs.
Lordship, this revisionist.
You have been convicted.
Yes.
What is the total compensation amount?
But total 11 lakhs 50,000. Both the parties have come to the court, they are present. The petitioner and the son of the opposite party.
But to begin with, you take 2 lakh rupees.
This is a classic illustration of that. Lordship, Samuel Beckett's waiting for God. 2014, I'm waiting for this meager amount of 11 lakh. Lordship, they are now, after a decade, paying me only 2 lakhs.
You take it first, then when matter settled, there is no issue.
No, it's for the purpose of referring to mediation.
Absolutely, Lordship. That's what I'm saying.
Who is complainant?
Complainant is present here, Lordship, from outside.
Mr. What is his name?
Umang Agarwal, son of the opposite party.
Pramod Shah. Pramod Shah is
I'm the petitioner.
the petitioner.
He is the complainant.
He has to pay.
Yes, sir. Pramod Shah has to pay, sir.
Yes, Mr. ଆସନ୍ତୁ କଣ ଆପଣ ପଇସା ଆରେଞ୍ଜ କରିପାରନ୍ତି ଆଉ ଯଦି ଡିସମିସ୍ ହେଲା ପରେ କଣ ହବ ଜାଣିଛନ୍ତି ଆପଣ କେତେ ଦିନ ଲାଗିବ କହୁନାହାନ୍ତି
The mediation, let you not go for
Yeah?
mediation.
I will pay, sir. Give some time.
you will pay so how much time you need
Yesterday, otherwise I given one man more. So yesterday I got
Agreement ballot, sir.
for years the matter was lying.
A minute,
Lord say nothing could be turned out there. Lord say therefore it has been brought back.
so that is the reason you try to be have a practical approach suppose
Take the money and go. What
suppose I'll dismiss what will happen will keep on running and moving to Supreme Court and all you won't get anything at least he is ready to
listen to the
What I am submitting a Lordship is they should think it appropriate to honor your Lordship's order dated 6th December 2006.
it's all right now they are giving 2 lakh rupees
Yes, sir.
you accept it I'm sending to mediation
Yes.
Mediation, your Lordship. Mediation will not be eligible for that because your Lordship nothing could be happened. I mean nothing could be settled in the local level. Lordship now this will be dragged for another few months. This is a revision of 2000.
so what do you want you tell me
What I will suggest you Lordship, outside court settlement would be appropriate Lordship. We can sit
That is for
together.
mediation, no.
Not mediation, your Lordship. Outside court settlement means we can sit together, try to settle the matter amongst ourselves. If anything happens to Lordship, we will come before Lordships and it is.
do it I have no problem you do it either I'll send it to mediation or you settle yourself go outside and sit and do whatever he is paying 2 lakh rupees
You accept it,
you
yes.
tell me I'll put it
Or your Lordship can record that he is agreeing to pay within a stipulated
this is
time.
neither here nor there either you settle or you argue the matter I'll hear it and finish it up I'm just giving indulgence because he has some personal difficulty and trying to show his bona fide by paying whatever 2 lakh rupees he has got it he's making a statement before court that he would be paying
Yes, sir.
and he needs little time I will accommodate otherwise if he doesn't pay then hear it and finish it up
Will be allowed to pay in installments, your Lordship, the remaining amount. So let's do this.
that is what he says installment you take it as a first installment take it as a first installment and the next installment when can you give
Sure, I will give you installment, but I need first, after this, I need some time to pay.
how much time you need sir you
That actually 2-3 months, I will pay. Sir.
then you give an affidavit
Next,
you give an affidavit seek the instruction from him let him give the timeline
Yes.
when he is going to pay how much
Yes, definitely.
you file an affidavit You file an affidavit, that will be the settlement terms.
Sure, please. No, sir.
And on the basis of that, I'll dispose it up. If
Yes,
he
yes.
doesn't pay, then we'll see.
Yes, sir.
He will revive.
Yes, sir.
He will revive
Yes,
his
sir,
revision
sure, sure.
petitions. Okay, you file an affidavit. I'll put it next Thursday. File an affidavit, and which is practically possible for
Yes,
him.
yes, sir. What
Not
about
that
the time?
if financially, if he's not capable of paying, there is no point. Give an affidavit. On the basis of that affidavit, I'll dispose of all
Yes.
the matters, keeping it open for him to revive the
Yes.
application. Okay. And you mention this.
Sure, sure.
Mention this. Give it back. Give it back. Mention and file it. Thursday. Thursday for filing affidavit. Okay.
Come take the draft. Let me take the draft and let the yes. The
ड्राफ्ट दे दियो तो आपको ना सी ड्राफ्ट लिखी करिए एफिडेविट फाइल करिए एफिडेविट सहित आपको दो ठीक है
please.
he will give it
Please.
obviously he will give it prepare the draft
Yes, sir. Not
draft of the affidavit
Written first.
give it to him Thursday
discuss the matter.
yes sir
Hello.
you file the affidavit I'll dispose it up Thursday you file the affidavit
Sure.
in the terms of the affidavit
Yes, yes.
I'll just come after 27 so here before hearing matters who is here yes 26
Item 26.
IC is on VC, my lord. IC is on VC.
yes
Namaskar, sir.
let us understand what was the fact I just want to recapitulate it what is that
My lord, the fact
you are
that
seeking what you are seeking
I
passing
am
of
passing of the affair, my lord.
yes
There is a case, my lord. I was an employee of a private company. I resigned in the year 2024, my lord, accepting a better offer, my lord. My joining report is there, my lord, under Annex 2, my lord. Thereafter, my lord, after 1 year, in the year 25, they, my lord, registered an affair. First, they gave a notice to appear before them. I approached this honorable court, and this honorable said that 141, they will release if the offense is not made out. What they did, they adding 409, they registered an affair. I am a private person, a private company. 409 is not attracted. I approached this honorable court has granted me anticipatory bail. And the allegation in the affair that in the year 22, some investigation was conducted by the income tax department. There some bogus purchases were shown that was taken to be company's purchase. For that, the investigation was taken on. There, the persons who have purchased some articles for me, some of the purchasers, some of the suppliers, they deposed before the income tax department. No, that is nothing to do with the company. That is, we have purchased for him. The income tax department closed the investigation. Now again, the same thing they have raised this here, and now nothing has happened. They froze my account. That has been released. Nothing material is no material is there.
you are on bail
I am on bail. And
Yes.
no material is there. No entrustment. For first month, there 3 offences. They have my 4 offences.
let us see what
Yes.
material he has got it
Yes.
what is his name
Jagannath Malik.
No.
He is my investigation officer.
P. Shamsundar Rao.
Shamsundar Rao
Yes.
Sir.
yes Mr. Rao
Sir. Sir,
What's the stage of investigation
sir, very shortly we will submit final form, sir. Within 2 weeks.
within 2 weeks
Sir.
you are going to file a closure report what
Sir.
are you going to file a closure report
Sir. Yes, sir.
then
Then I have nothing to say.
wait what he did let's see
Fact remains that the 2 witnesses who belong to Andhra, they are sending the letter to the RCO, but they did not come. So that's why I talked with the IAC. We can proceed in the
close it if
Yes.
nothing
Yes,
comes
yes.
out why somebody will suffer like this
Very fair.
Ah. I'll list it next Tuesday. Let us
Yes,
see.
yes.
Next Tuesday.
Yes.
Okay. Thank you, Mr. What is his name?
Rao.
Thank you, Mr. Rao.
Sir, namaskar.
Conclude it this way or that way. Whatever you want to do it.
Madam, may I pray, my lord, let it come month of August. That's why in the meantime,
After 2 weeks.
2 weeks ହେଲା ଦି ସପ୍ତାହ ସେ କରୁଛନ୍ତି ନା ତେଣୁକରି ଟାଇମ୍ ଟା
ଦି
ଲାଗେ
ସପ୍ତାହ ସେ କହୁଛନ୍ତି ଯଦି ଆସୁ ଆର ୱିକରେ ଯଦି ନ ହେଇଥିବ ନେବ
କମ୍ ଟାଇମ୍ ଦେଲେ he can close all these things for that.
Let it be on 21st. Okay.
Yes.
21st.
21st.
If it doesn't happen, we'll see.
Yes.
Yes.
Doesn't happen, we'll see.
Yes.
Don't pressurize him also because he has.
Because of that, the FTR in the year 2025 till that.
Let the IO take his call. Huh?
Yes.
Okay.
Item 27.
Most of it.
Distance of the IO.
No, yes, he's dispensed. His presence is dispensed. Don't take it as a pressure from the court. Do whatever you want.
Sir. Thank you, sir. Sir.
Okay.
Namaskar, sir.
Yes.
My pleasure, Lordship, man. Contact matter man.
What content?
Order dated 7/11/2025 has not been complied with, my lord. Your Lordship, man, on 24/4/2026, directed state government to take instruction, man. 24/4/2026.
Which order you are complaining?
Annexure 1/7/11/2025.
What was the direction?
Man, can you relevant page 9, para 5,
Yes.
27. Be that as it may, I feel it appropriate to dispose of the petition with the direction to the opposite party to do well, to see that the petitioner's final pension and other retirement benefit is sanctioned and disperse expectation. If there is no other legal impediment, the petitioner shall furnish all necessary documents to the opposite party of two to satisfy regarding his entitled pension or other retirement benefit within a period of 2 weeks.
Have you submitted all the papers? Yes. Yes. Who is appearing for the state?
On 24/4/2026, you will see directed statement to take.
Yes. This order was passed on 7/11/25.
Petition is submitted.
Direction for 4 weeks to comply. Mr. Bull has appeared last time. I mean, what is the stage? They have not complied what?
No.
File is also not with us. So
Shall I pass it over?
next week.
So I will pass it over. The pensionary benefit direction is there.
But the petition
All
is
the-
suffering from brain stroke, man.
Yes.
Brain stroke.
No, this is.
Left side
I'll pass it over. Just check it up. Huh? I'll ask Mr. Bull.
Yes.
Let's see. He might have got some instructions. Yes, we'll see. Okay. Yes. Then 100?
115 last time.
This is in the what category? For hearing.
This is for hearing, my lord. The revision petition, my lord.
Before it is start, my lord, I am the informant. It is a SC/ST case.
So this is, my,
So-
as far as my client is concerned, my lord, he is not charged with SC/ST.
But proceeding is under that section. I being the informant, I have a right to be heard in 15A.
Yes, yes.
My lord, but copy of the application I have not been implemented. I have, so that I have filed an application for to implement me as a party. I have not been implemented.
Where is the application?
Yes, flag C.
The discharge petition, my lord, he did not appear there. So therefore, he could not be made a party here. And this is the second round, my lord, before your lordship. And in this case, what had happened was I was not named in the FIR. There are two incidents which happened. And this to happen. One is at 11 a.m. The other incident which happened was, which they alleged, happened at 5 p.m. where I am named. Now, if your lordship, if I may trouble your lordship with your lordship's own order in the first round, why your lordship did not interfere at that stage? Because your lordship was of the view that under 227, a discharge application is maintainable, and your lordship granted me liberty to move the trial court, raising all the grounds. And what the trial court has done, my lord, not a whisper of any of the grounds raised, in a most mechanical manner, quoting two judgments, my lord, they have rejected my discharge application. If your lordship will permit me, I may.
Anyway, my application may be considered first. In the earlier round of litigation, I was.
So let us see where is the charge sheet. Let us see.
The charge sheet, my lord, may kindly come.
But my application has to be considered first. If
No,
I-
what I'm trying to say is whether in the charge sheet the SC/ST provision
No.
is invoked.
Against
Yes.
me, no.
But the case is, he may be charged in different count. But other accused persons are there.
Have you filed protest petition?
My lord?
Have you filed?
No,
protest
no,
petition?
no.
See, if in the charge sheet
My submission is limited. I have filed the application. If my application will be allowed to intervene, then they will serve a copy on
No,
me.
I'm on the application only. Let us read the application.
Yes.
You have a right, then you have a right. Nobody can stop it. Let us see whether you have a right or not. Let us understand. The statute provides that you have a right.
15A, my lord. Yes.
15A provides a right. Whether these provisions are invoked or not, that has to be seen. Let us see. The initial FIR was under various penal provisions as well as SC/ST. After investigation, whether the charge sheet is filed.
Yes,
If
sir.
the charge sheet is not filed in SC/ST, have you filed a protest
Charge sheet
petition?
is filed under SC/ST, but so far the present petitioner before Lordship is concerned, he is charge sheeted in the said case in the charge sheet in the penal provision, not SC/ST.
Because he is a part of a different.
And that's why, my lord,
Whatever.
He is a part of a different incident as per their own case, as per the prosecution case, and that has come very candidly in your lordship judgment also. It is-
Let us see that judgment.
Please, that's
We are
why-
hearing his application. We are hearing that.
Please, that's why I just
Because
want to-
see, why to leave it some technical?
No, I don't want your lordship to trouble.
Let us see the.
So, please, your lordship may kindly start from page 105, my lord.
Yes.
Page 105, your lordship judgment starts.
Okay.
And my lord may kindly come to page 107.
107, huh?
107.
Yes.
Second paragraph.
नहीं नहीं
It is
copy नहीं है मेरे पास. How can you refer to all these things while my application is being heard? You serve a copy on me first.
Now, if I may read, my lord, it is undisputed that neither the name of the petitioner was mentioned in the FIR, nor any allegations have been made against him in the FIR. The petitioner was nowhere in the picture at the time of incident. The FIR lodged by the complainant, my lord, may kindly make note of this. This your lordship had taken note of earlier also. The FIR lodged by the complainant was registered at 10:04 p.m. on the same day. Now, then last paragraph, after the lodging of the case on the same, the statement of the complainant was recorded by the investigating officer of the case.
Show me the charge sheet first. Let us see the charge sheet.
The charge sheet, your lordship, may kindly come to page, starts at page 30. For me, my lord, may come to page 52. The charge sheet starts at page 30, my lord, of the paper book. The charge, if your lordship may kindly come to page 52, my lords, of the charge sheet.
Yes.
Page 52.
52.
Please, my lord. Now, page 52, your lordship may see this is the first paragraph. I'll just take your lordship to that. On dated 1/11/22 at about 11:30 am, Ganesh, along with other workers, namely so and so, and others were working in Z1 phase 2 area as per the order of project manager, owner of Z1 apartment. During the work, they went so and so, explained them to work. When Ganesh told them that they were doing their duty, Malay Panigrahi, so these are the other accused, my lord, and security guards, so and so, threatened them with dire consequences, abused Ganesh in obscene language, apprising his caste, expressing his caste as Sara, Chota Jati, Kandra, Tora, Panchayat, whatever. So they assaulted him, other workers, by means of an iron rod and wooden flank with an intention to commit murder, for which Ganesh sustained injuries and fell down on the ground. When he screamed for help, Patra arrived here and tried to save him, but Malaya Panigrahi and abused Ramchandra in filthy languages and assaulted him by means of iron rod and wooden flank with an attempt to commit murder for him, for which Ramchandra sustained bleeding injuries on his head and fell down unconscious. They also assaulted Dhobi Nayak by means of and so. During the tussle, they were also damaged. So this is the first part. Admittedly, I am not even present there. Now, Brandon McCann, this is the concocted story which is
second
at about second part. At about 5 p.m., Bindu Bhushan Nayak, that is the petition before my lords, of Z1 resident arrived there. He also abused in vulgar languages to Tapan Mohanty and his workers. While other workers, now, my lord, I also take note of the fact that Tapan Mohanty was not present there. While other workers were made to report the matter, Nayak threatened them to the workers for dire consequences. During course of investigation, spot was visited. Complainant witnesses were examined who were proved the charge and occurrence against the accused person in the testimony. Injury equals so and so. And then, my lord, may kindly turn to the last 6 lines, my lord, 11. Nayak have been arrested and forwarded to so and so. And this is the charge. If your lordship may kindly see 5th line from the bottom.
Yes.
And Nayak, under section 341, that is wrongful restraint, 294 obscenity, this thing, and 506 criminal intimidation. Investigation is completed after sufficient. Now, this is the charge sheet. So, charge sheet before, my lord, I was charge sheeted, and the charge has also been framed under 341, wrongful restraint, 294 obscenity, and 3rd criminal intimidation. So this is the thing. And then now may I take your lordship back to what your lordship had observed in the first bit. That's very crucial. Now kindly come to page 118 of your lordship judgment. This is the conclusion with your analysis of your lordship. What your lordship said in that case, my lord. May I read 118, my lord?
Yes.
There are 2 pages, my lord, I'll trouble your lordship with. After hearing the learned counsel for the parties and going through the material available on record, it is very much clear that as per the admitted case of the prosecution, the petitioner was not present at the spot when the alleged initial scuffle broke out between the complainant and the other accused person at 11:30 p.m. It is further admitted case of the prosecution that the complainant was taken away from the spot to a hospital for treatment of his injuries after the alleged initial scuffle. Moreover, the prosecution has itself stated in their charge sheet that the alleged role of the petitioner started only after 5 p.m. in the evening. Thus, the court finds that both alleged incidents are not part of same transaction and rather both are distinct offenses. Thus, both the alleged incidents ought not to have been clubbed together. The builder developer was neither present. Now, your lordship, this is important. This is Tapan Mohan. The builder developer was neither present at the time of initial incident in the morning, nor was he present at the time of incident in the evening. However, his name has been floating in the background of the entire incident behind his back. The charge sheet does not disclose the presence of the builder at the time of alleged use of abusive language and extension of life threat by the petitioner to the builder. Even the builder has no complaint against the petitioner. However, at the same time, the court cannot lose sight of the fact that the witnesses have categorically stated in the statement recorded under section 161 CRPC that prior to this incident, there have been altercations between the parties which make the alleged threat made to builder who was not present in the spot palpable in the minds of the worker who came to the location allegedly on the instruction of the builder, although it goes without saying that the veracity of such allegations cannot be gone into at this stage. Now, what your lordship directed after? Having regard to the aforementioned facts and submission at the bar, I am not inclined to entertain this petition at this stage. Rather, I think it appropriate to relegate the petitioner to learned trial court to urge all the points and seek discharge by moving appropriate application. This is being done only because of the reason that there are overlapping facts germinating from the record and many documents which are the part of the charge sheet have not been placed before this court. The contention of the learned counsel for the petitioner, the subsequent incident in the evening by which the petitioner has been roped in this case is a distinct offense, could also be tested by learned court below on the strength of the document. So this is the direction which your lordship has passed.
Yes.
On the document form part of the judgment on the basis of the face, allegations that are not made out should be seen at the time of framing of charges. Now your lordship may kindly come to the order rejecting my... Now my lord may kindly come to page 139.
Yes.
This is the order of the
All facts and narrative.
section. Now I have heard both the counsel, but I am reading page 139.
139, yeah.
139. But these paragraphs are relevant because what we submitted was exactly in the line of what liberty your lordship had granted us. The learned counsel for the accused petitioner has submitted that the accused is innocent and no way connected with the allegations alleged by the prosecution, but he has been falsely entangled in this case. The entire case is based on assumptions, conjectures, and without any legal basis. The accused is a chartered accountant and elected as secretary of the Resident Welfare Association, which is developed by so-and-so, headed by one Tapan Mohanty. The RW is at loggerheads with the developer for various statutory violations and unfair trade practices in construction of phase 2, 3, and 4 in the detriment of phase 1 resident of the same project. The RWA has serious objection to the developer storing its construction material for phase 2 and 4 in the basement of phase 1 and thereby raise the demand of rent for such illegal occupation of the said. However, the developer has tried to forcibly enter the basement and use it for sales purposes on several occasions, leading to constant tussle between the RWA security personnel and officials of the developer. On 1/11/22 at 11:30 a.m., the developer sent around 150 to 200 men to the phase 1 of the said society who entered forcefully into the basement, leading to a scuffle with the security personnel deployed by RWA. As the security personnel were outnumbered and badly beaten up, the members of the RWA intervened to end the fight, which led to registration of the so-and-so. The complainant has alleged that on 1/11/2022 at 11:30 a.m., while he, along with other persons, some security guards, were removing some construction material, accused number 1 and 2, along with security guards, came to the spot and started hurling filthy languages, indicating his caste, and said, "So I am not here.
You are not accused number 1.
I am not accused number 1. I am not accused number 2. I am not there. This is an admitted position."
That's said.
Then the accused petitioner was absent during the aforesaid incident. The name of the petitioner was not mentioned in the FIR, nor have any allegations been made against him in the FIR. So it is further submitted the facts are alleged by the prosecution do not disclose.
These are your submissions, which
Then,
you have
then, my lord,
come to the
your lordship
conclusion.
may kindly come 141, para 3, the special PP submission. Then my lord may kindly come to 142, para 4.
Yes.
Now, what he says is, in case of so and so, the Honorable Supreme Court following 7 guiding principles. Now he quotes those guiding principles. Your lordships are well aware. I am not troubling your lordship. May kindly turn over the page.
Further, the state of Karnataka.
Further, in state of Karnataka, and then he quotes that by projected through and evaluated if the court thinks so. He again culls out the ratio. In the instant case, last time that was.
From the statement
From the
of defense,
statement
seizure of
witnesses,
these-
Caesar list and other available in record, prima facie shows the complicity of the accused petitioner in this case, so reasonable grounds are found to proceed. And then, my lord, and he rejects and
SCST.
and the very next page, he on the same day, he rejects my application and frames charges. Now, your lordship, what I am not there in under any offence under the ST Act.
That's right.
The very interestingly, my lord, the offences, if your lordship may kindly see those relevant sections. IPC.
No, I could understand it. The trial court has not dealt with the
Any of the propositions, and my lord,
yes, in so far as the 15A is concerned, see, there are two distinct.
I am not regarding the impugned order, but fact remains neither in the trial court nor here I have been supplied with the copy. But and further fact remains in the earlier litigation for quashing the cognizance, I was made a party. Charge sheet was there. I was made a party, but here I am not made a party. Only my submission is 15A.
Yes, read 15A.
15A, Lordship kindly 6, subsection 5.
Yes.
A victim or his dependent shall be entitled to be heard at any proceeding under the set in respect of bail, discharge, release, purge. Here discharge. So I must be made a party. I must have a opportunity of being heard.
He has been charged, not discharged.
Discharged. Now he has been charged. His application for discharge is rejected. Against that he has come.
But see, the impugned order is completely vague order.
That's right, my lord. But when I have come, unless I have taken on the record,
You are right. I am not on that. But
then on that ground also, your lordship kindly demand the
the trial courts are expected. Trial courts are expected to apply the mind at least.
Yes, sir.
You can't.
The order is not with me.
Principles and
What I have heard, he has not applied. Only
I will call. See, what I'll do is I'll call for the because this is a revisional jurisdiction. I'll call for the record. I'll call for the record, and meanwhile you supply the copy.
We will do it today.
What he's saying, trying to say is try to appreciate one thing. A charge sheet was filed. In the charge sheet, very interestingly, in the charge sheet there are two distinct events. In the second event, he participated. First event, he doesn't participate. In the first event, ACST is involved. In the second event, ACST is not involved. So therefore, in true sense, you may not be a party, but since the charge sheet is filed under, why to over?
No, my lord, in the interest of justice, what falls
You,
from my
you
lord.
should be heard. You should be heard according to.
Yeah, we
You supply the copy.
We bow down, my lord.
You supply the copy.
I may be implemented and a copy may be
Implemented.
served.
You are
Copy will be
happy.
served.
During the course of the day, you supply the
Soft
copy.
copy will be served immediately.
I'll call for the record
Please.
from the trial court
Please, madam.
and see. It may be a case of. I'm just,
At best, my lord, when his grievances have not been taken care of, and technically it is past what I have heard, it is fair to be set aside and to remand.
Remand. That's the only thing I think at this stage. Maybe I don't know. After hearing you,
But madam,
I'll
your
call for
lordship may also consider that it's a fit case after once the discharge application has been rejected on frivolous and without application of mind at all, my lord. So now, when I'm before your lordship in the revision petition, your lordship may also consider this to be set as, to be quashed.
that I've not heard you.
No,
Just I got a overall idea.
Since my learned friend said, so I just in response to that only. This is only a
And
response.
you have a very decent and difficult opponent.
No, my learned friend is always a very difficult and very.
Wagner is a very decent and very difficult also.
I have
at the same time.
all respect for him.
It's very erudite.
Very learned person.
So I'll pass the order.
Then,
I'll allow your
only
application.
two players, my lord. I have no objection to that. One, my lord, listed on 10th, your lordship may stay that procedure because it becomes very difficult last time, my lord, presenting that application with utmost respect. The judge was very adamant, my lord, and it was with great difficulty that. So, your lordship, my learned friend is here only, is going to hear the matter finally. May fix up a date, my lord, and put that in abeyance.
The LCR is
Qua the
petitioner.
petitioner. No, I'm only saying qua the petitioner. I'm not saying that.
But he's saying something else.
Once LCR is called for, that amounts to stay. Nothing remains there.
Well, but
I'll see. I'll pass the order.
And my lord said one more request. We may be supplied a soft copy of LCR so that we may be able to assist your lord.
When it come, then you can take
It is
it.
here. It is here, man.
No, it hasn't come.
LCR has come. That's what I am told.
I don't know.
LCR is there already.
LCR there.
You can take. You also.
So it amounts to stay.
LCR is already there. What to do?
So unless and until your lordship
Yes.
passes an order.
Yes.
No, sorry, my lord. He may be right. Soft copy of the LCR is.
Maybe. I'll pass it. And you take the soft copy. Both of you can take. Both of them.
And my lord, the order may be out before,
Yes,
before 10th, my lord, because otherwise they will. The judges.
I'll pass the order right now. Yes. Okay. Yes. Take the soft copy, both of you. Mr. Bag, your application is allowed.
Your lordship is fixing a date, man.
Yes, Mr. Bag, how much time you want? I can fix it somewhere in August, which first week or second week. Tell the date you tell.
Any date you also be fixed.
Let it be on
Thursday, if it can be, madam.
Thursday, then let it be 20th of August. 20th August. 20. Okay.
Please.
Okay.
I'm so grateful, madam.
Yes. Start now.
Deeply okay. Great.
Yes.
Hearing notice.
Item 28. Anybody is there ready, then we can proceed. Anybody is there?
28, your
Mr. Naik is there.
specifically fixed for today, your lordship, for
Yes. Mr. Moon is supposed to come. Mr. Moon is supposed to come. Let it be 2 o'clock. Mr. Moon may come.
Lordship, after lunch, I have some difficulty. Let it be taken up Thursday.
Okay, you have a difficulty. Okay. Thursday, huh? Thursday, if you tell Mr. Moon, can you intimate Mr. Moon?
Lordship can fix it up at 2:30. Maybe Lordship, I'll finish up and join 2:30.
Today.
Your
Yes, you come at 2:30, no problem.
Yes, your lordships.
Okay,
I'll finish
2:30.
up and come back, your lordships.
Yes. If it's possible, we will proceed. Otherwise, next Thursday. Okay.
Yes, your lordship.
You send your junior, huh? Send your junior.
Yes,
Who can. Yes. Yes.
Item 44 can be taken.
Yes. If you are ready, why not? "44.
Lordship, I will be permitted to submit on behalf of Mr. D.K. Mishra. Lordship, this appeal has been preferred, challenging the order of conviction and sentence passed under section 326 of the Indian Penal Code
wherein the wherein the appellant has been sentenced to 3 years of rigorous imprisonment and a fine of rupees 1,000.
Yes.
The prosecution the appellants faced trial for the charge under section 302. The prosecution allegation was that
From 302 to 326.
yes, my lord.
You're not happy. Yes.
Well, that's my the prosecution case is that on 10th of July 1999, the appellant and the deceased had a quarrel in the weekly market.
Yes.
In the course of the quarrel, the appellant allegedly dealt 2 kick blows on the stomach of the deceased. They were separated. The deceased was thereafter, he complained of having abdominal pain, because of which he was subsequently transferred to the nearby PHC. And from the PHC, he was later shifted to Jaipur hospital, and he succumbed in Jaipur hospital on 26th of July 1999. That is after 16 days.
Yes.
Lordship, the prosecution examined 16 witnesses, amongst whom PW 1, 2, and 7 are the alleged eyewitnesses to the occurrence. PW 11 is the treating doctor, PW 12 is the doctor who conducted the postmortem, and PW 15 is the IOMan. The learned trial court, on appreciation of the evidence on record, has held that as the case is not of one wherein the appellant had the intention or the knowledge to cause death or such bodily injury as is likely to cause death, and as the evidence of the PW 11, 12 and 12 would show that the cause of death is my lord, septicemia due to internal peritonitis. So, taking these factors into consideration, the learned trial court convicted the appellant under section 326 and sentenced him thereunder.
Yes.
My only submission is that, my lordship, if sees section 323, if I may place the same, voluntarily causing grievous
Item number 43 and 46.
Yes, we can, today we can, if you are ready, we can.
Yes, I'm
43, sir.
43 and 46.
43 and 46. What are the offenses?
One is 306, other is 498 is 304B.
306.
Both comes over like
Okay. Then you tell Mr. Naik and Mr. Moon, take it Thursday. 2 matters. Any matter you want to mention? Maybe. Okay, these 2 matters. Yes. Okay.
The Honorable Chief Justice has specially indicated that my law is supposed to be hearing. And it has been passed out before my law. And
Which matter is that?
Vigilance matter of SP police. And there's no question as to such case.
It is appeal. Of which year?
21.
Is marked to this court.
And specifically marked, my lord.
Acha.
It was heard for some time.
Take it.
Well, he has a bereavement in the family, he has lost his wife, my lord. He's almost, he doesn't want, whatever be the result, my lord, he wants actually the matters to be heard and disposed of.
Okay, I'll try and include it.
Whichever case, my lord.
Yes. I'll just see. Yes.
Item 18.
18, eh? 18?
What?
Morning petitioner was not there. I'm for the opposite party. That 1,50,000 check.
Oh, who was 1 lakh?
Morning also petitioner's counsel was not there. The lordship posted.
You are for complainant.
I'm for the complaint.
What is this matter is about?
My lord, certain documents relating to the case was marked as exhibits. That has been challenged before your lordship. That order is, my lord, at page 27. 1/3/2024.
Mr. P.C. Jana.
Yes.
Mediation also failed.
Yes.
Annexure 5.
Tax inverse challenge, these have been marked to the exhibits.
You are the complainant, you wanted to, you mark this document.
Marked and he has posted to put up for defense evidence. No, not.
This is criminal miscellaneous, no? I'll just dismiss from the court. What to do? 138 matters pending. See, this complaint was filed when?
21.
21 complaint, 1,50,000 rupees. And it's going on and on. It's 5 years. The petitioner, they say in the order dated 1/3/2024 passed by JMFC bracket R Baleswar in 1 CC case number 71 of 2021, whereby the trial court allowed the complainant respondent to mark exhibit, mark certain document as an exhibit as reflected in the impugn order. Despite the objection by the petitioner. Therefore, the petitioner is aggrieved and has resorted to the present proceeding under by invoking the inherent jurisdiction of this court under 482 CRPC. This present matter is pending since when it was filed on July 2024. Notice was issued to the respondent on 16/5/2024 on 24. After the respondent appeared before this court on the consent of the matter was referred to mediation by document 18/5/2026. From the mediation report, it reveals that the mediation remained unsuccessful. Thereafter, the matter listed before this court final disposal. However, none has appeared for the petitioner to press the petition, hence the same is dismissed. Yes. Vacated, obviously, marriages. Yes, dismissed. As a consequence of which, interim order passed earlier. There is no interim order here.
Lordship granted them, they will seek adjournment and the court will adjourn the proceeding.
Interim order, if any, shall stand vacated. Yes. Yes.
43.
Main feature also. Here the appellant
appellants, my lord. They have been convicted for the offense of the section 306 of the Indian Penal Code. My lord, initially, charge was framed under 498, 304B, 302 by 34. The Indian Penal Code reduced section 4 of DP, the Dowry Prohibition Act, against my lord, 3 appellants, Indumati Das, Jogi Das, and Kalucharana Das. In between Jogi Das, death is lost as per the instruction received by the Government Council. Died on 9/12/2019.
Yes, it is abated by the order 89. Yes.
Against him. So appeal is pending now against Indumati Das and Kalucharana Das.
Jogi Das died, huh?
My lord?
Jogi Das?
Yes, sir. My lord, after a prosecution to substantiate the allegation, has examined 6 witnesses, and out of the witnesses, PW1 is the mother of the deceased, and she is the informant. PWs 2 and 3 are 2 doctors, those who have conducted the postmortem examination. PWs 4 and 5 are 2 sisters of the deceased, those who have claimed to have witnessed the occurrence. PW 6 is the ASI.
Yes.
The London trial court, after analyzing the evidence on record, is to reach a conclusion. Prosecution has failed to prove the case against the accused persons for offences under 498A, 304B, and 302 by 34 of the Indian Penal Code, and under section 4 of the DPI.
Yes.
So that is observation in paragraph 14 of the judgment.
14.
14.
Okay. Yes.
Premises, it is concluded that prosecution has failed beyond all reasonable doubts to bring home the charge under 498, 304B, 302 by 34, and 4 of DPI. But convicted the appellants for the offence under 306, for which no charge was there.
Yes.
My lord. What I want to submit before my lord, whether conviction can be made under section 306 of the Indian Penal Code in the absence of the charge against that, yes, it can be termed to be a minor offence comparable to 304B. But in the trial court has reached a conclusion there is no case of 498A and 4DPI. So the presumption under 113A cannot be attracted in that respect. Yet, if 490 conviction would have been under 498A, one of the ingredients of this presumption would have been attracted.
Yes.
So reaching at a conclusion abruptly that it's a case of 306 in the absence of any specific questions in that respect in 313.
What are the facts?
I'm coming to it. But here the case is deceased was in love with accused Kalucharan, and she eloped with him, and they got married in a Jagannath temple. And in the year 98, and she died on 11/7/99.
Yes.
Well, at 2 doctors, PWs 2 and 3, might be kindly see the evidence. They have neither reached at the conclusion death is homicidal or suicidal or accidental. They could not reach a conclusion because they say we can give this opinion after examination of the viscera. That viscera has not seen the light of day. So in the absence of that finding, a court has also tried to extract to the doctor. Court has put questions in that respect.
Now let's see 2.
My lord, 2 and 3. My lord, let's see. Two. No injury was there. So no finding that it was suicidal injury. Nothing is there. say visceras were preserved for chemical examination in paragraph 4. From the above findings of the postmortem examination, the opinion as regards cause of death was reserved till opinion of the chemical examination.
Mishra is received.
Examination of Mishra is received. Time since death till PM examination was within 24 hours. So and so. The injuries found on the deceased could be possible by assault with blunt weapon. The injuries found be due to assault also by suffocation by pressing the body. I have not mentioned in my report, cross-examination by the defense, I have not mentioned in my report if the injuries found were antemortem or postmortem in nature. The injury on the right elbow could be possible by fall on rough surface. Something found on the nose could be possible by poisoning. In case of only assault, clothing will not come out from the nose to court. The findings of my postmortem examination were not sufficient medically to opine cause of death. Cross-examination by the prosecution. From the findings, suffocation would have been referred as cause of death, but we rule out poisoning. Examination of viscera was necessary. I have not mentioned about suffocation in my report. The findings were more in favor of suffocation, but not conclusive pending chemical examination. So everywhere this says, or doctor says chemical examination report is necessary. But that report, well, that court has reached a conclusion. Finding is, madam.
Let us next Dr.
PW3. PW3, same matter. That is, we have not mentioned in our report if the injury found on the right elbow was antemortem or postmortem in nature. Paragraph 4 minute. That injury was simple in nature and could be possible due to pressure. This injury could be possible by fall, even though there was injury to subcutaneous tissue. I cannot give the cause of death to court. The findings we got did not lead to any conclusion on cause of death. On viscera's examination, the cause of death would have been ascertained by chemical examination and histopathological examination. So, injection of poisonous material or death due to asphyxia or any disease, any process, any opinion on these on the cause of death, basing on the finding, would have been provisional. Death due to suffocation would be assessed from viscera's examination. In absence of ligature mark, death due to suffocation cannot be.
Yes, how do you say?
And finding is, what is, let me see, that is at paragraph 8. I'm sorry. Paragraph 8, sorry, page 8, para 7.
Para 7, huh? Yes. So next is
My lord, at 10th line. Sorry, it is with regards to contradictions. With regards to chemical things, my lord, that is last quarter.
Paragraph 12.
12, last quarter. Paragraph 12.
Non defense counsel.
Handing defense counsel.
On the contrary, admitted that prosecution case it will be taken to have has failed to prove the actual cause of death at the cost of
repetition. It may be mentioned that both the doctors, PWs 2 and 3, have claimed to reserve their opinion on cause of death subject to examination of viscera and Visual examination report has not come to record.
The IO has also been negligent in not subjecting the seized the bottle said to have a content poison seized from the house of the accused person to chemical test. But all the same, death of the deceased has not natural as it is both ocular and medical evidence, and such death was a
So, in the absence of that,
if you see page 9, para 7 last couple of lines, last couple of lines. The reasoning is, so these facts lead to, let's see, last 5, 6, 9, para 7. So these facts leads to the conclusion that non-acceptance of the deceased by the accused person, Jogi and Indumati, as their daughter-in-law, and what is just interestness, what is this, of the accused, Kalucharan, to come to the cause of his wife, deceased,
cause of his deceased wife
and indifferent attitude of
the
informant and their family members led to the unnatural death of the deceased and the accountability of the accused persons so to the ultimate and unnatural death of the deceased to be
113A,
inferred by 130. This is presumption. How will you get the presumption? Unnatural death. Where is the finding of unnatural death? Cause of death is also not
when the
known.
court is acting on 498 and 4 DPI, no demand, no torture.
My lord, that is the
So 113A case, 113A टा
See, 306 ର ingredient fulfill होची की नहीं देखी दियंतु बस. Let us see 306. What are the ingredients? Just see. And those evidences there or not, just see.
Abet failed to commit suicide.
Suicide, yes.
And in what way he abetted? And when is suicide?
Nature of death is not confirmed.
If any person commits suicide, whoever abets the commission of such suicide shall be punishable with the imprisonment of either description of
abatement definition पढ़ो paragraph
107.
107.
Well, it has been held by the apex court. But I have very short note for
a person abet the doing of thing who first instigate any person to do that things, or secondly engage with one or more other person or persons in any conspiracy for the doing of that thing, if an act or illegal omission takes place in person to that conspiracy and in order to the doing of that things, or had intentionally aids by any act or illegal omission the doing of that things. Here in the case, my lord, that is the period 4 and 5, there are two eyewitnesses. They are stated that torture. May I plead with the period 4? Period 4, and there are two doctors, they are the chief.
Torture kata to disbelief wala 498.
Disbelief, acquitted. You have not challenged that.
That part, so as the PW 3 2 is concerned, doctor evidence, my lord chief. Doctor evidence, period 2, bodily build was average, blood type.
The argument which is being advanced by a non friend has been answered by Supreme Court in 2001 Supreme Court. Considering the legal position between the said offence under section 306 of IPC and with the introduction of 113A of the Evidence Act, the offence under 306 has acquired wider dimensions and has become a marriage-related offence. In a case reported in 2014 Supreme Court 1482, Mangatram versus State of Haryana, I have given that. The Honorable Apex Court, considering the provisions, has been pleased to observe in para 26 that if a married woman commits suicide within a period of 7 years of her marriage, the presumption under 113A of the Evidence Act would not automatically apply. The legislative mandate is that when a woman commits suicide within 7 years of marriage and it is shown her husband or any relative of her husband has subjected her to any cruelty, the presumption as defined under the 498A may attract. Having regard to all other circumstances of the case, that such suicide has been abetted by her husband or such relative of her husband. The term the court may presume, having regard to all the other circumstances of the case, that such suicide has been aborted by her husband would indicate that the presumption is discretionary. In the present case, the trial court has reached at a conclusion that the prosecution has not proved the case against the appellant and others for the offence punishable under Section 498A and Section 4 of the PI, which otherwise denotes there was no demand of dowry and consequential no torture for dowry, which led to commission of suicide. In other words, to attract the presumption under 113A of the Evidence Act, the basic requirement is that the prosecution is to prove with sufficient materials to draw a presumption so as to fall under 113A of the Evidence Act. The scope of Section 113A of the Evidence Act and Section 306, 107, 498A has been examined by Honorable Apex Court in Hansraj versus State of Haryana, AR 2004 Supreme Court 2790, where the Honorable Apex Court has been pleased to observe, unlike Section 113B of Evidence Act, a statutory presumption does not arise in the operation of law merely on the proof of circumstances enumerated in 113A. Here, my lord, in the instance case 498A, 4DP Act is not there. And no question pertaining to abetment to commit suicide is there. So, Section 3, I was going through the statements recorded out of 313. It's not there. And in the absence of any specific finding to the effect that she has committed suicide, because the prime duty of the prosecution would have to give the viscera report, produce the viscera report.
There are 2 eyewitnesses and there are 2 doctors.
No, Hansraj para 13 just read. Hansraj para 13.
And under Section 216 of the CRPC, the court can alter.
That's right, but see, the cruelty part is not believed. Nothing is believed. Hansraj, see, para 13. Page 19 of your compilation.
That I put it.
I will get over it.
Before I think with the judgment, it may be recorded the third oral of the documentary evidence. Defense has not.
Court has disbelieved witnesses in that.
It's a plea of the alibi and
it says that even if you prove that there is a cruelty, that ipso facto will not, 113 will not operate unless the ingredient of 306 independently satisfied. That is says. Here your case is worst. The cruelty is not at all proved. So therefore, what is left with you is all ingredient of 306 has to be independently adduced through evidence. And the doctor is not able to ascertain
positively whether of death. The doctor has not ascertained the cause of death.
It is a suicidal or accidental or it is homicidal. Nothing is there.
Because of the chemical report has not come up. That's why they might not.
Now, how will you say it is a suicidal death? Death is of either suicidal or homicidal or accidental.
Yeah, but
this is the foundational fact. Thereafter you proceed further. How will you say that it is a suicidal death? It may be a murder.
And categorically, they say, both the doctors say, in the absence of visceral report, we are not.
We can't say anything.
But the evidence of the doctor that some injury in the body.
Therefore, 302. Let it be 302. I am talking about 306.
Accurate.
It may be 302. You should have appealed. You should have filed, no, it's a case of 302. Injuries are there. presumption under 113 304B is there? Nothing. You have not said anything. On his appeal, you can't, now.
Comment
After such a long time.
That was dealt with the paragraph 12 in the judgment.
Yes.
The
What does it
IO has
say?
also been neglected, is not negligent in not subjecting the seize the bottle said to have contained the poison seized at the house of the accused person to chemical test, but all the
Para 12?
para 12 last.
Citing the decision, okay.
Tapare. Not a defense counsel.
IO.
Yes, my lord. Was not natural as in such both the ocular and medical evidence and such death was suicidal as in the suggestion of the defense. So even if the mode of adopted to the commit suicide by the deceased has not been on so coming the prosecution not to be stand on the way of driving presumption of the 113A of this inadvertent.
This finding says that it should be 304B.
In this position, that acquitted the 304 and 302 and
306 straight away without any reasoning.
And the 4 year.
113A presumption is says that operates.
Presumption that suicide to be married woman. When the question is whether
the decisions which have been taken note of by the law and trial court are not at all applicable to the facts of the case. So, it's a sadhana.
The court has power, you can alter the
charge.
216. 216. At any point of time, mind what's 216 should have died.
464 use kari karpatan.
216 and 113.
The 113A, just see, read.
Yes. Presumption to the abatement of suicide by a married woman.
Yes.
When the question is whether the commission of suicide by a woman had been abated by her husband or any relative of her husband, and it is shown that she had committed a suicide within.
Also, she has, and it is shown that she has committed suicide. This evidence has to come first. Okay, next.
Within the period of 7 years from the date of her marriage, and that her husband or such a relative of her husband
subjected to cruelty.
Subject to her cruelty.
So the cruelty part is not believed.
That part, the
cruelty part is not believed.
One of the ingredients to attract 113A is
cruelty is not believed, gone, and it should be a suicide. Evidence has to come and suicide. Both the doctor says that we can't say whether it's suicide, homicidal, accidental, we can't say. So where is the ingredient of 113A?
Presumption to attract that presumption is 3 ingredients are necessary.
And what is the finding? It says that despite shortcoming of the prosecution, and it says last, if you read paragraph 12, last, so even if the mode of adopted to commit suicide by the deceased has not been unearthed, these shortcomings of the prosecution not to stand on the way of drawing presumption under 113. How can you draw presumption? In what way you can draw presumption? You tell me. How will you draw the presumption?
My lord, we see the judgment which I have given, Mangatram versus State of Haryana, page 42.
Mangatram.
My lord and friends, all queries the answer.
No, this is against the fundamental principles. Yes. Mangatrama.
Page 42, paragraph
Yes.
28. 28, 29, 30, 31. Detailed manner. Abatement of suicide has been quoted. 306 has been quoted. But after that, 113A presumption has been quoted.
Yes.
30, my lord, we are of the view that the mere fact that if a married woman commits suicide within a period of 7 years of her marriage, the presumption under 113A of the Evidence Act would not automatically apply. The legislative mandate is that where a woman commits suicide within 7 years of her marriage, and it is shown that her husband or any relative of her husband subjected her to cruelty, the presumption as defined under 498A may attract, having regard to all other circumstances of the case, that much suicide has been abated by her husband or by such relatives of her husband. The term, the court may presume, having regard to all other circumstances of the case, that such suicide has been abated by her husband would indicate that the presumption is discretionary. So far our present case is concerned, we have already indicated that the prosecution has not succeeded in showing there was a dowry demand, nor would the reasoning adopted by the courts below would be sufficient enough to draw presumption so and so. That has again 31 has been paragraph 31 has been stated.
Yes. No, presumption will not be. What is this?
Up to paragraph 33, my lord, exhaustively analyzed. We are of the view that the circumstances of the case pointed out by the prosecution are totally insufficient to hold that the accused had abated his wife to commit suicide, and the circumstances enumerated under 113A of the Evidence Act have also not been satisfied. In Pinakin Mahipatra Rawal versus State of Gujarat, this court has examined the scope of 113A of the Evidence Act, wherein this court has reiterated the legal position that legislative mandate of section 113A of the Evidence Act is that if a woman commits suicide within 7 years of marriage and so and so, conclusion is there.
That Pinnock judgment is also there. Yes.
Yes, but I have given that.
And close.
That is 2013, but 10 was SCC page 48.
Yes. Yes.
That is the case.
Nothing there. Nothing is wrong. Evidence. Okay. 113 capital A requirement is also not satisfied. 306 requirement is not satisfied. Evidence are like that. What to do? And the trial court has rightly not believed the cruelty part and acquitted 498A. Once 498 goes, then one of the ingredient of 113A goes. So again, everything collapse there. If you would have been convicted under 498A, then 306 would have been sustained. That's the whole difficulty with you. There, state should have come. Their state should have come. They are serious offences.
Yes,
State should have come. Acquittal in 304B.
302, 304.
That acquitted 302, 304B.
He should have come.
And at that time, the 498 also, they are acquitted the 498 also.
And what is the age of this Hindumani? 45 years in 2000.
Mother-in-law, applicant one is 72 years and applicant three is the 58.
Very old. Everybody is talking to you. Okay.
Next case is pilot 498-304B. Correct?
South 192.
गुरुवार का ये गुरुवार
अपन ready ना थी?
Here, my lord, the entire case rests on.
Let us understand the fact. I'll add the end, don't worry. Let us understand. It will assist you also.
Here is a case, the entire case rests on a letter purported to have been written by the deceased. I am using the word purported because that letter was produced by the father of the deceased during trial.
Okay.
Neither the handwriting of the deceased has been verified, or in any respect, it can be taken to be a letter written by the deceased. But that has been
Have
taken
you
out of.
objected to it?
Yes, but it has question has been put to the IO. IO says it original was not given to me.
Now, when it was introduced in the evidence, have you objected to it?
But the questions have been put, but it should have been objected at that stage. Question has been put in that way, but I am showing that. That immediately strikes me.
You allowed some document to come on record what to do.
And let me see EW5.
The art of cross-examination, where to stop, where to not to stop, those things have to be taught to the trial court lawyer. Many of the conviction is because of the defense lawyers. Many convictions, if you see, defense lawyer only unnecessary they'll put question, which is not necessary.
That happens because they want to impress the client who was.
They'll put some question which is not in the cross examination sheet. They'll extract.
I have attended not less than 1,000 sessions with my senior. Not less than 1,000. But many a times I've seen put very sub questions, 3-4 questions, and I have seen other lawyers they randomly put questions, and answer by my senior was they are beating around bush. Some questions will click, then okay.
And in that process, you extract many evidence against you. That's the whole difficulty.
So what my senior is raising, there is another point of law. So suppose the document is not actually admissible in evidence. If that document was marked as an exhibit without the objection, what is the evidentiary value of that document?
That goes, evidentiary value is not there because fundamentally that's good.
So even if it is marked without objection, if it is not admissible in evidence.
But it has to be argued at the time of it's not even argued also.
This is an appeal. Appeal is continuation of the
trial.
Can be raised.
You are absolutely right. But what I am trying to say is the defense lawyers, because of them only the conviction.
Yeah,
if you leave it like that without defense,
here we cannot build up cases. That is just.
So that is the reason the trial court lawyers has to be taught.
There are some cases, madam, I have seen. Accepting the entire case of prosecution, no case is there.
Yes.
No prosecution necessary. There the lawyers, what they say, they have been paid for that to go to conduct the trial. Client is there, his relations are there. So to impress them, some questions have been put. And in the process, they are getting
invite evidence against them.
That happens. And some cases are there where even the best lawyer of world conviction will be there because evidence is telltale. And some cases are there where the talent of the lawyer is necessary. What to do, and what not to do, how to twist the prosecution case, and where to put the defense case. That is the talent of the lawyer.
Where to stop?
What to stop.
But senior being the member of the bar council, he can execute the.
This is burden duty of
Yes, the judicial
trial court lawyers.
By reading books, the art of prosecution will work. It's not something.
No. Reading book will not work. Reading book will not work unless
practical work is
unless you go to the trial court and sit and learn. Book is knowledge.
ସେତେବେଳେ କହୁଥିଲେ ପୋଥି ବାଇଗଣ ବାଡ଼ି ବାଇଗଣ law in book and law in practice
all together.
Here, questions have been specifically put to the IO.
Who is the informant here?
PW5.
5. Yes.
Nothing was there before marriage. Let's say after the marriage, a letter before the death of the deceased, she had written a letter which has been marked as Exhibit 5.
No, the PW5 at last line, page 33, it says, I have filed the said original letter today and also given the police earlier the photocopy and Xerox copy.
And that has not been subjected to verification whether the letter was written by the deceased or not. And that is the basis of conviction.
Exhibit 5 and 6, 5 to 7.
No, 5 to 7 to 5 সেটা সেটাকে ভুলে লিখে দিয়েছে 5 to 7 days thereafter. 7 days thereafter.
Marked exhibit
5.
6, 5 to 7, 5 to 7 days.
সেটা exhibit 5 তারপরে অর্ডার হওয়ার কথা 5 to 7 days thereafter.
5 रहेगा था 5 to 5.
IO says, yes, to substantiate this letter, the brother has been examined, say PW 7, but she has been examined after 1 month of the occurrence. And I say, it is a fact that I did not state before the police that my sister was ill-treated for 20,000 and that my sister sent Exhibit 5. It is a fact that I did not state. So to corroborate that Exhibit 5, he has stated in chief parenthesis, I came to know from the villagers of so-and-so that my sister Lakshmipriya had been murdered. After marriage, when my sister Lakshmipriya and her husband Antarjami came to our house, we came to know about their demand. 7 to 8 days prior to death of my sister Lakshmipriya, we received a letter from her containing the demand of dowry of rupees 20,000. My sister Lakshmipriya read up to class 7. But that's fact he had not stated before the IO.
He says that we have also not reported this matter before the police after the receipt of the letter, Exhibit 5. We also not found any information of the loss.
But this brother of the deceased, but he was examined after 1 month, he says. He is a very vital witness, being the brother of the deceased and knows about the fact.
Where IO says, what the IO says?
IO evidence. Okay.
He's only 17, huh?
Okay. We see paragraph 6. I am not accepting the ownership of the Bajaj scooter. I have also not seized any relevant document relating to Bajaj. I cannot say if the Bajaj belongs to accused Antarjami. The original of Exhibit 16 was not given to me by the complainant by the time of its seizure. It is a fact that the PW5 has not scribed in his affair.
When does he say what Exhibit 5?
With regards to this Exhibit 5, also not stated in the affair. But the in-laws of the deceased demanded one curtains and dressing table. It is a fact that PW8 did not state before me that he marked any injury on the neck of the deceased and his brother-in-law has received a letter from the deceased. It is not a fact. This is the basic Exhibit 5. Nothing is there. Rather, a villager has come, immediate neighbor, who has not been declared hostile. When 2004 Supreme Court married, if it will be seen that that the witness says, I am the immediate neighbor and I have seen the deceased was roaming the village and she was talking herself and behaving. That is the answer in the 313 statement also. that she was bad, mentally retarded, and she was behaving unruly, is that, and might have committed suicide. That is 16. 16. But let me see the evidence of P 16. And the immediate neighbor of the accused person, the wife of Antarjami, was staying happily in her in-laws' house. The accused persons have bus, jeep, as well as landed property and the cycles of wife of Antarjami was unusual behavior, and she was talking to herself and laughing without any reason at times.
But in the impugned judgment, it is not only Exhibit 5, there are other evidences are also there.
Ocular evidence. Which evidence are there?
The trial court deals with other evidences also, apart from
PW5.
PW5.
PW5 and brother of the deceased and brother-in-law of the deceased. 3 evidences there.
Yes, page 14.
Page
14.
Page 14 is the
Yes, judgment. Yes, here, paperbook, page 14. Para 6 of the judgment. Internal page 6. PW5. The father of the deceased stated in his
that was drawing violence attention.
evidence. Yes, that para.
PW5, the father of the deceased stated in his evidence that his daughter Lakshmipriya married the accused Antarjami Giri in the year 2000, and further stated after a few days her in-laws demanded, there was no demand before marriage.
After marriage, yes.
After marriage, a few days her in-laws demanded dressing table and rupees 20,000 as a matter of dowry, which he came to know from his daughter. He further stated that he expressed his inability to his daughter that he cannot pay the amount at a time. He further stated that for the last time, when his daughter went to her in-laws' house, told him that they are ill-treating her and asked him to arrange the demand amount in any manner. There was no allegation in that respect. People in police, if there was any such allegation. PW5 further stated that his daughter gave him a letter by Exhibit 5. That letter
Agreement.
That exhibit 5, which the accused persons are disputing,
Yes.
containing demand of dowry. In cross-examination, my lord may see their letter. I put it in AI because it's Bengali language or something. Bengali. The language is English translation says, please accept my respect, salutations first in this letter and convey my respect to the elders. Since returning from your place, there is trouble ongoing at home because 20,000 rupees was not given. Everyone in the house is displeased with me and treating me badly. Please try to arrange the money. Well, let me see this letter, the exhibit 5. Bengali, Telugu and
Exhibit 5.
Exhibit 5.
Yes. This is a small letter, huh?
Small letter.
Only it says that they are not satisfied because of 20,000.
Displeased with me. Bengali. I have English version of this. I don't know how far it's correct.
But she doesn't say that I have been tortured physically. They're not displeased, that's all. But the trial court says ill-treated her and asked him to erase the demand. See, they were not satisfied. Therefore, ill-treated is one thing. Demand is something different. They may not be satisfied. Whether they demanded or not, that is the question. If they are not satisfied, doesn't mean that they are demanded. They may not be satisfied. But the demand, where is the demand of dowry? That part, from the letter, at least.
And letter is the basis. If presumption will be 113B will be taken into consideration soon before. Soon before is this letter. They have tried to introduce this letter only to attract the ingredients of 113B. Because with regards to 304B, the presumption is under 113B. Like 306,
113 like A.
I have got a decision with regards to this letter.
And it says that from the FIR in also, from the evidence of PW5, it reveals that he came to know from the daughter regarding the demand of Godrej Almira, dressing table, as well as 20,000 rupees. Whether in the letter it is written regarding Godrej Almira and dressing table, 20,000 rupees. You have to see very carefully this thing.
And pertaining to this pilot, a letter, I have got a decision of this Hon'Ble Court, 2017, volume 67, OCR 105, by Honorable Justice Sankar Mishra. There the letter was produced as exhibit A. It has been disbelieved by the court. My Honorable, let me prepare matter to this. And matter the English translation. I don't know, my Honorable also may get it.
You also verify whether rightly translated or not.
Yes.
We'll see. Yes.
Item 55, 54, 3 months. ଜଣେ ମରିଗଲାଣି ଆଉ
An
ଦି
applicant
ଜଣ
one already died,
pure
the other applicant is there.
55.
Yes. First offender having no incidents. And so for SI for 3 months under 354 IPC, and SI for 2 months under section 323 506 IPC. And out of 2, applicant number 1 is died.
This matter will be taken up on first.
Yes.
There was a 138 matter. He was there.
Mr.
I have verified the law on the subject. Because I have
The word through is not
Honorable
there.
Justice Chandrachud is there. If the legal notice contains something about the authority MD or something, then non-filing in the complaint petition is
There is a curable defect.
curable, but it's not there. Minor notice.
Who died here?
Appellant number 1, Ramkali Baria.
Already abated.
Yes. Against whom appeal is abated. So for appellant number 2 is concerned that Chotu Singh Bue, that's SI for 3 months under 354 IPC. SI for 3 months.
355.
354. And so far, SI, 323 506 SI for 2 months. They were in custody for some period. Thereafter, on bail.
354, 323.
Yeah. And
I'll grant PO and finish.
Yes.
Grant PO.
They are also in custody for 11 days.
11 days.
Yes. First offender, no.
Pure, yeah.
11 days. Custody. PO.
Yes. So for appellant note, that appeal is abated.
Order तो अच्छी है bit everything.
आइए. बंगला केस আসলে
Huh?
ये बंगला पढ़ी पढ़ी तो मुझे बंगला केस
She will translate it. Okay. Thank you. What is it?